appearances.
Good afternoon, Your Honor. David King here on behalf of the plaintiff.
Sir, your name?
Sorry, Judge. Fellas Lane.
All right, this is the date for non-jury trial, and this is a non-payment of rent case. How much is the plaintiff claim is owing?
Your Honor, the total balance at this time is $3,320.17 plus court costs of $161.
3,000, I'm sorry, 3,000.
$3,320.17.
All right.
Hey, Your Honor,
Sir, of that amount, is there any that
Before we even step into this courtroom, you need to understand. You're about to witness one of the most frustrating, bizarre, and oddly fascinating legal showdowns you'll ever see. This is not just a simple unpaid rent case. This is what happens when real-world law collides head-on with sovereign citizen ideology. A belief system that insists rules, contracts, and even money itself don't apply the way the rest of us understand them. At the center of this case is Trellis Lane, a man who truly believes he has cracked some hidden financial code, one that allows him to live rent-free by tapping into what he claims is a secret credit system tied to his identity. Sounds wild? Just wait. On the other side, we have Judge Simpson, calm, sharp, and absolutely not the one to entertain legal fantasy. If you've ever wondered what happens when courtroom patience meets pure nonsense, this is it. Watch closely, because this case isn't just about rent. It's about logic versus illusion, facts versus belief, and a judge who is about to dismantle.
I can break down that amount if you want me to, Your Honor.
Pardon?
I can break down the amount if you'd like me to.
Just one moment, we'll get to that. Sir, can I ask you, I received the documents from you. Is there a reason why you don't think you owe that amount?
because it's already been paid, Your Honor. Far as reporting adverse information about a co-signer Act 211 of 1989, Vanessa Place is trying to held me liable as the co-signer when I have interest and a signature and I'm a natural person. So they're trying
Okay,
to
so
hold me liable.
let me ask you this.
Okay.
Just so that I have the background on it. You reside in this unit that's at I think 315B
Correct.
at 1000. You reside there.
That's my place of abode.
Well, you live there, right?
Depends what you're talking about. I'm acting as a consumer. So, far as like I'm there on special appearance and my estate.
Here is where the pattern begins to reveal itself. And if you've seen sovereign citizen arguments before, this will sound very familiar. The refusal to acknowledge debt isn't just denial. It's rooted in a belief that traditional financial systems are somehow illegitimate. Notice how quickly the defendant dismisses the idea of owing anything at all. There's no hesitation, no uncertainty, just a flat no. But here's the critical issue. Courts don't operate on belief systems. They operate on evidence, agreements, and transactions. And what makes this moment so important is that the judge isn't arguing yet. He's simply gathering facts. He's giving the defendant every opportunity to explain himself clearly. And that's where things start to unravel. Because when someone is confident in a system that doesn't actually exist in reality, every explanation becomes
Leaves here to go to what they would call home. Where does this person that's sitting here go?
To my place of abode, Your Honor.
Which is where?
Apprentice place.
Okay, at the 315B.
Correct.
All right, that's what I need to know. Okay. Do you have a ledger?
And I'll give Mr. Lane a copy also.
Thank you.
And Mr. Fantera, this would be your witness, is
Yes.
that correct? Okay, why don't we do this? Why don't we have her and Mr. Lane sworn in, please?
Thank you.
Yeah, one.
Right hand. Swear affirm the testimony you're about to give. Okay.
I do.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, could I give you real quick context on that?
Yes, please.
We had a previous case last summer where Mr. Lane received Sarah funds. And when we had I have a copy, I have a case number, I have a copy of the unsigned copy of the COD. That was entered on September 9th. SOS paid his rent through September, and it left a small balance of, I think about $119, which we waived. So the balance, even though it doesn't show it on there because we didn't actually get the SOS check till sometime later, his rent at the end of September was $0.
Got it.
So the total balance that's on there is 5 months of rent at $513, water and sewer bills, electric bills. There's not even any late fees. And then there's 161 in court costs. So I just want to clarify that, in fact, none of this goes back past September 30th. In fact, I don't know if you remember, we actually, when we had the previous case, Mr. Lane had sued Peninsula Place seeking the return of all money he paid forever. And he denied that he owed money, but simultaneously applied for Sarah, and he denied he applied for Sarah. You verified with probably Aaron at the time that he had applied for Sarah. He ended up getting Sarah funds. He would not sign the COD, and then you basically gave him a choice. I'll enter the COD, or we'll have a trial and I'll give you a judgment. But it sounds like he's raising some of the same stuff now that he attempted to raise.
But it's actually one of the most telling moments in the entire case. The defendant is attempting to separate himself into different entities, a so-called natural person versus some kind of legal or corporate version of himself. This is a cornerstone belief in sovereign citizen ideology. The idea is that the real you isn't responsible for contracts. Only this constructed legal identity is. But here's the problem. Courts do not recognize this distinction in the way he's describing it. To the legal system, you are the person who signed the lease, lived in the property, and benefited from it. And you can already see Judge Simpson narrowing the focus. He's not entertaining philosophical arguments, he's grounding everything in reality. One simple question: where do you live? Because no matter how abstract the argument gets, reality always.
I'm here on special appearance.
No, you can't do that. You are not an attorney at law because you can't appear for somebody else. So my question is, and I'll ask it again, are you Trellis Lane?
Yes, Your Honor.
Thank you. So, Mr. Lane, October of 2022, did you pay rent to the landlord?
Yes, Your Honor.
Okay, and how did you pay that?
I'm paying with my credits that's on file. So I sent instructions back in May, basically to get my account zero every month.
You do what?
I sent instructions back in May, then I sent another one to December to the CEO.
The CEO of what?
American Campus Communities. Saying it right. So he's seen my email, so he's aware of what's going on. Basically, like I say, I'm looking for consideration. I have not been getting no consideration, no adequate consideration.
Well, you get adequate consideration for the contract and any payment by virtue of the fact that you have a residence. So I don't think consideration is even an issue.
But yeah, I have several questions.
Well, you can go ahead and ask your questions, but I don't know. Let me just ask this. October 2022, how did you pay your rent?
I paid with my took the bill, I endorsed it.
Did you give them cash?
We don't have,
We being whom?
I'm saying, it's a credit system, Your Honor,
So what?
credit system. We don't.
So who's in charge of this credit system?
So who's in charge?
Surely.
I mean, we haven't had money since 1933, the American Bacon Act.
We being whom? Who are you talking about when you say we haven't had money? Who is?
Being even more interesting and frankly, more damaging to the defendant's case. Listen carefully. He admits he applied for assistance, but then immediately claims he didn't understand what he was applying for. That's a huge contradiction. Why? Because applying for financial aid acknowledges the very system he's now trying to deny. You can't simultaneously say this system isn't valid and then attempt to benefit from it. Courts pick up on that inconsistency instantly. And this is a classic example of what happens when someone tries to juggle conflicting narratives. On one hand, he's claiming independence from the system. On the other, he's relying on it when it suits him. That contradiction doesn't just weaken his argument, it completely undermines his.
What they do is every month they bill the utilities. So he gets this bill, and then you'll see at the bottom what he writes is pay to the order of Peninsula Place. And so what he's taken, so for example, the top one says pay to the order of Peninsula Place, $662.12. That amount is his monthly rent plus the $123.12 in utilities that are at the top. There's 3 of these that I've attached. So what he does is he cuts off the bottom and he mails that in as with instructions to pay to the order of Peninsula Place as if that's a check.
Have this marked as plaintiff's exhibit and 2. The ledger being 1. But Mr. Lane, you have a copy of what I've marked as plaintiff's exhibit 2. Is what Mr. Fantera described, is that correct? Is that what you do?
Yes, I'm accepting the credits that's given to me and I'm transferring to that.
Who's giving you this credit? They who?
So Peninsula Place, so in the beginning, when I signed up with Peninsula Place, I gave my principal information. So those payments are supposed to come to me as credit. So
what payments?
The payments that's coming every month. So those payments, they're trying to hold me liable for it, and I'm taking the credits that I'm receiving and dishing it back to them, to Peninsula Place.
Who's giving you credit?
You said who's giving me credit?
Yeah.
I have credit, Your Honor. I have a security interest.
In what?
And this so-called contract with Peninsula Place.
Okay, but who's giving you credit? Young man, you keep using these terms, payment, credit, and it seems to me as I'm listening to you that you're using them improperly. So my question is, have you paid anything to the plaintiff in US dollars or anything that evidences US dollars?
No, I haven't paid in US dollars.
Or anything evidencing US dollars, like a check, credit card, anything like that?
So this is...
No, that's a yes or no.
Can you repeat the question, Your Honor?
Have you, let me just break it apart so we get it real clear. Have you paid for the months of October 2022, November 2022, December 2022, January 2023, or February of 2023? Have you paid to anything to Peninsula Place in US dollars?
No, Your Honor.
Have you paid anything to them that is evidence of an account which holds US dollars?
Yes, Your Honor.
What? And what account is it attached to? You better be careful about answering my question. Because if you're telling me that you
Is critical and honestly a bit of a turning point. The judge asks a very simple yes or no question. Are you Trellis Lane? And instead of answering directly, the defendant tries to sidestep it with special appearance language. Now, this tactic is commonly used in sovereign citizen arguments to avoid jurisdiction. The belief is that if they don't identify as the legal entity named in the case, the court somehow loses authority over them. But in reality, it does the exact opposite. It frustrates the court and accelerates the process toward a ruling. Notice how Judge Simpson shuts it down immediately. No debate, no confusion, just clarity. Either you are the person named in the case or you're not. And if you're not,
Show you the balance.
Yep.
Just showed you the balance.
No, you haven't shown me anything. Show me the balance on the account. If you give somebody something that evidences that they can access US dollars, then there is a balance on that account in terms of what you're giving them. Much as if somebody gave a check to them, they would be able to show the account for which they can then present that check and receive US dollars. Show me that account, Mr. Lane.
Like I said, Your Honor, I don't know what else you're asking for. This is the
No, you know exactly what I'm asking for.
you're asking for something that's coming out.
Something that evidences that by that piece of paper that you've given them, that they can access US dollars.
Okay. I don't have any other account besides this, Your Honor.
You don't have any what?
I said I don't have any other evidence besides this right here.
That does not show me that they can access US dollars.
Okay.
Where would they take that to, in your mind? Where would they take that to access United States dollars?
Put it on the ledger.
Where would they take it to access US dollars?
So, okay. So, Your Honor, so I got a question. As far as landlord and tenant relations, relationships.
it's honestly one of the most revealing parts of the entire case. What the attorney just described is not a payment system. It's essentially the defendant taking a bill, writing "pay to the order of" on it, and treating it like a check. But here's the problem. That's not how financial instruments work. A valid payment requires an actual source of funds, an account, a bank, something verifiable. What he's doing is creating the appearance of payment without any substance behind it. And this is where many people get misled. On the surface, it might look official. It might even feel legitimate to the person doing it. But legally,
It's in here.
I'll try to answer your question as soon as you answer mine.
Okay.
Where would they take it to access US dollars?
They will take it and take the check and put it on the ledger with my credit. Because if I owe something, Your Honor, it would be in the negative balance. How can I pay something that's in a positive balance? How can
You don't have a positive balance.
this is
You have given them a piece of paper that you yourself just said is a check. So where would they take that to access your account
so, Your Honor,
and receive US dollars?
they're acting in dishonor. They're taking it and they never said anything about or object to it. So it was off.
Oh, they're objecting now, certainly. Where would they take it, Mr. Lane?
So where would they take it? I mean, as far as they have a security deposit deposition bond. So they have it in a financial institution.
What financial institution
I'm not.
would they take it to get cash from your check, as you call it, that would then be debited from your account? Where would they take it?
Debited. So what about the credits, Your Honor?
I don't see a credit.
On this paper, it says credit payments and credits.
That's not what it means, to the extent it says that. You have no credit. Where would they take it to get US dollars?
So where would they take it? They would take it out of my trust, Your Honor.
Out of your trust.
Yes.
Where is this trust located?
We all have a trust in them.
Judge Simpson is doing something very important. He's simplifying the argument down to its core. Forget all the terminology, the buzzwords, the references to trusts and credits. The judge is asking one basic question: where can this payment be turned into real money? And this is where the entire argument collapses. Because no matter how complex the explanation sounds, if it can't be converted into actual US dollars through a recognized financial institution, it has no legal value. Watch how the defendant struggles here. The more the judge presses for specifics, the less concrete the answers become. That's a key indicator in any argument. When clarity disappears under scrutiny, it usually means the foundation isn't solid to begin with.